Good afternoon, everyone. My name is Victoria Romero, and on behalf of CAM-CCBC, I would like to thank everyone for watching this webinar. For more than a year now, CAM-CCBC has been hosting online events in order to encourage all spectators to remain safely at home. And it's not the first time that CAM-CCBC has teamed up with NYU to promote discussions on topics involving arbitration in the Brazilian and international arbitration scenario. As an example, the Brazilian Arbitration Day at NYU, which will later be approached by João. Considering this webinar is entitled, Does a Right to a Physical Hearing Exist in International Arbitration? We take the opportunity to emphasize that CAM-CCBC has maintained its efforts to maintain its administration functions intact during the pandemic in consideration to the arbitration society and our clients, our servers of our users. As an illustration, we point out two administrative resolutions which were issued, one in 2020 and the other in 2021. Our administrative resolution number 40, 2020, has set out rules for exchange of electronic submissions and has promoted guidelines for the conduction of virtual hearings. And our administrative resolution number 46 of 2021, which was just inaugurated, has just inaugurated our expedite procedure, a much more cost-efficient option to submit relatively low-cost arbitrations in comparison to our regular rules. And these efforts were carefully outlined by our recently re-elected president, Ms. Eleonora Coelho, as well as the re-elected board members. And last but not least, as usually done by CAM-CCBC, we have selected Gerando Falcões as the charity to which we encourage all spectators to make any donation that you deem should be useful for them. It's an institution based in Brazil that works with families affected by COVID-19. And to make your donation, we kindly ask you to click on the link, which will be sent on the chat. And now I pass the word to João Gabriel, who will introduce the panelists of the event, and we hope you have a great webinar. Thank you once again.
Thank you, Victoria, and good afternoon from New York. As you said, my name is João Gabriel Campos. I'm an LLM candidate at NYU and the current Vice President of the Brazilian Legal Society at NYU. The Brazilian Legal Society at NYU, or the BLS, is a student organization founded in 2016, which aggregates current and former NYU Brazilian law students. The BLS's major goal is to establish a forum in which Brazilian issues, legal, political, economic, can be openly discussed and addressed. If you want to know more about the BLS, we invite you to visit our profiles in social media. On behalf of the BLS, first I would like to thank CAM-CCBC for not only agreeing to host this webinar, but also for agreeing to host the second edition of the Brazilian Arbitration Day at NYU. The second edition of the Brazilian Arbitration Day at NYU, and please take note of this, will be held in the second semester of this year. Second, I would like to thank the ICCA for kindly supporting this event. Third and finally, I would like to thank all the other members of the current board of the BLS who came to the United States in such challenging times, namely Paula Lima, Felipe Pereira, Giovanna Del Nero, Mariana Ferez, Nathalie Kenji, Mafia Coelho, Eduardo Schneider, Jéssica Buschler, Ana Beatriz Vale, and Luciana Rocha. Without you, this event would not be possible. Without further ado, I'm now pleased to introduce our guests for today's event. Our moderator will be Benedetta Mauro, who is a junior associate at BR Arbitration and Litigation, a tutor of the Certificate in International Commercial and Investment Arbitration, and who has a Master in International Law from Luiz Guido Carli University. Benedetta, I'm sorry in advance if my pronunciation is mistaken. Benedetta will moderate a debate between Marcel, Engholm, Cardoso, and Rafael Francisco Alves. Marcel is a legal consultant at Chaffetz Lindsey, LLP, has an LLM from New York University, and a Master in Procedural Law from the University of São Paulo. Rafael is a partner at MAMG Advogados, a professor at FGV Law, São Paulo, and an officer of Brazilian Arbitration Committee, SEBA. Rafael also holds an LLM Arthur T. Vanderbilt Scholar from our very own New York University, and a Master of Laws and JSD from the University of São Paulo. Benedetta, good evening. I think it's around 8 p.m. in Rome right now. The floor is yours.
Hello, João. Thank you very much for your kind introduction. Thank you also to Victoria. And of course, thank you to CAM-CCBC and to the Brazilian Legal Society at NYU for inviting me today. I am very happy to moderate this panel. The idea today is to try to answer the question whether there exists a right to a physical hearing in international arbitration proceedings seated in Brazil and the United States. And we will try to do so by presenting the survey results from these two jurisdictions in a research project that was recently launched by ICCA precisely to answer this question. Before starting our discussion, I would like to take a few minutes to introduce the ICCA project, which is led by co-editors Giacomo Roca Sergheta, who is a professor of law at Roma Tre University and the founding partner at DR Arbitration and Litigation, and James Hosking and Yasmin Lalou, who are both partners at Chaffetz Lindsey LLP. The objective of the research project is to tackle the new legal questions posed by the surge in the use of fully remote arbitral hearings due to COVID-19. All these questions revolve around the core question, that is, whether the parties to an international arbitration have a right to a physical hearing. The project's methodological assumption is that there cannot be a single transnational answer to this question, but that arbitrators will inevitably have to look at first the law of the seat, that is the law regulating the proceedings, and second, the law of the place where recognition and enforcement of the arbitral award may be sought. Therefore, the need to collect reliable jurisdiction-specific information and make it available to the international arbitration community. With this purpose, in September last year, the co-editors launched a call for expressions of interest to respond to a standard survey questionnaire. As it can be read on the webpage dedicated to the project on ICCA's website, the response to the call was impressive, with around 150 expressions of interest from over 80 jurisdictions all around the globe. In the following months, in a joint effort with the selected national reporters and with the support of ICCA and ICCA's president, Lucy Reed, the co-editors have released the national reports from 77 New York Convention jurisdictions, the last 31 of which were just released yesterday. So I really invite you to visit the webpage dedicated to the project on ICCA's website, where all the national reports are available. Finally, I would like to mention that the project and its findings have been shortlisted for the Best Development Award at the 2021 GARA Awards, which are taking place on July 1st. Now, having said that, we come to our debate, which will follow the structure of the survey that was sent to the national reporters. So Rafael and Marcel will guide us through three main topics that are: first, whether a right to a physical hearing is provided for in the Brazilian and US lex arbitri, either expressly or by way of interpretation. Second, what is the impact of the parties' agreement on the arbitrator's procedural discretion to order a remote hearing? And third, whether remote hearings can affect the validity and enforceability of arbitral awards. Finally, just one final note for the speakers. I just would like to beg you to be mindful of the timing, and I apologize in advance for interrupting you in case I see that we are running out of time. So now, Rafael and Marcel, if you would like to open your cameras. And Rafael, so please tell us whether a right to a physical hearing exists in Brazil.
Thank you, Benedetta. Let me start by thanking NYU Brazilian Legal Society for the invitation. João Gabriel is here with us. Thank you also CAM-CCBC. Thank you ICCA for putting up this event today. And I should also thank, of course, the editors of the project, Yasmin, James, Giacomo. It has been a great pleasure to collaborate with a national report on Brazil on this. And now Benedetta too, and of course, it is also a pleasure to share this panel with my colleague Marcel and with Benedetta, who has also been involved in such project. To answer your question, Benedetta, under Brazilian law, as I mentioned in my report, the Brazilian Arbitration Act has no specific provision regarding a supposed right to a physical hearing. The Arbitration Act, the Brazilian Arbitration Act, only determines that the deposition of the parties and examination of witnesses shall occur in a given place or in a given location. That's all. And that, such testimonies and depositions should be recorded in writing. Those are the only requirements under Brazilian law. It is debatable whether location, the Portuguese word location or place, which is in Article 22 that I just mentioned, 22 paragraph 1, would require a physical location, or whether a remote location would also be acceptable. To be honest, in Brazil, this debate, it's not even controversial at this point. We are already within more than 12 months within this pandemic. And from the beginning, I would say as of March 2020, the Brazilian arbitral institutions, they were very quick in responding and adapting to the pandemic and shifting whenever possible the hearings to remote hearings. And we haven't seen much controversy on that from the parties or arbitrators or arbitration users in general under Brazilian law, which could mean that the arbitral community is satisfied with the idea that under the Brazilian arbitration law, no physical hearing is required. And when the act mentions place or location, it could be a remote location, could be a virtual hearing without any specific problem. And I think this is, as I mentioned in my report, not only the community has embraced virtual hearings in Brazil from the outset, as of March 2020, not only there's a sense of, there's a relative consensus in our community in that regard, but also I think if we interpret correctly the Brazilian Arbitration Act, I think in other provisions, whenever the act mentions place, for instance, there are other provisions determining that establishing requirements for the place where the award is rendered, at least 3 or 4 other legal provisions under the Brazilian arbitration law mentioning the place where the award is rendered. And among scholars and practitioners and under Brazilian case law, it is accepted that when we mention that the award was rendered in Miami, Florida, it doesn't mean that the arbitrator should be there to sign the award actually in Miami, Florida. Under our law, the fact that the city is elsewhere doesn't mean that the arbitrators should be there physically. So the idea of whenever the Brazilian Arbitration Act mentions place or location, the idea that doesn't mean necessarily the physical location is already established in our case law and among scholars and practitioners, I would say for at least 20, 25 years. The Brazilian Arbitration Act was enacted in 1996. So we are celebrating 25 years now. And there's no debate that the arbitrator should be physically in the location to execute the award, for instance. So when Article 22, paragraph 1 mentions that the position should take place in a given location, it doesn't mean necessarily in a given physical location. The idea is to give the parties in upfront, in advance, the correct date, the correct time, and the correct location, to give the parties a fair warning of where the hearing is taking place. That's the idea of Article 22, paragraph 1, not a requirement that it takes place in a physical location. And so I would say there's no express provision under the Brazilian arbitration law requiring a physical hearing. And by interpreting the act as a whole, I would say that it is also acceptable under Brazilian law to hold virtual hearings. And this is what we have. This is what has been happening since March 2020. So the controversy is not, at least in Brazil, is not whether there would be a possibility of having virtual hearings, right? There's no right under Brazilian law, as I mentioned, to a physical hearing. So yes, it is possible to have virtual hearings. That's the answer. The discussions and the debates that we're having is not the virtual hearing per se, but the challenges that such virtual hearing poses to the parties that I can mention afterwards when we discuss party autonomy, when we discuss set-aside procedures and due process. So we're not discussing here whether there could be the possibility of virtual hearings. There is such possibility. The Brazilian Arbitration Act accepts that. There's no requirement for a physical hearing. That's not only my interpretation, but the general consensus here in our community. And this has been happening for at least 14 or 15 months right now, with no, I would say, with no critical problems because of the virtual hearings per se, right? We could have other discussions afterwards, but that's my initial answer.
Thank you, Rafael. Thank you very much. Marcel, and how about the United States? Is the situation similar?
Thank you, Benedetta. And I echo my colleagues' words in thanking CCBC, BLS, ICCA, and the editors, Giacomo, Yasmin, and James. So in trying to answer this question, I'll first try to summarize what's the legal framework for arbitration in the US, and then I'll get into the actual question. So differently from Brazil, so in Brazil, you would have the union having most of the legislative power to enact federal laws right across all states. The United States is the opposite, right? So state law is most common, and the union has very specific and narrow subject matters in which it can legislate, right? Which the states have delegated to the union via the Constitution. So one of those specific subject matters is commerce, when it's commerce between states and with foreign states. So that's the reason why Congress back in 1925 was able to enact the Federal Arbitration Act to deal with arbitration. But the Federal Arbitration Act does not occupy the entire field of arbitration, so state law still can come into play. And the way it does is state law can also be applied as long as it doesn't contradict what the Federal Arbitration Act says, right? Otherwise, the Federal Arbitration Act preempts what the state law provides for. And in very exceptional circumstances, some circuits accept that state law can be applied over the Federal Arbitration Act if parties expressly and specifically agree that they want state law to apply with the Federal Arbitration Act, but that's very exceptional, right? So getting into the actual question of whether there is a right to physical hearing in US lex arbitrae. So in relation to the Federal Arbitration Act, we can say that hearings are a very important aspect of arbitration under the Federal Arbitration Act. And we can say that because the FAA allows courts to vacate awards when a tribunal refuses to postpone a hearing when good cause is shown, right? But other than that, the FAA does not have any provision which relates to how hearings shall be conducted. So it's silent on that point. And that's not surprising because the FAA was issued almost 100 years ago. So congressmen at the time were very unlikely to be concerned with this issue. So the FAA does not have any express provisions on the right to physical hearings. As to state law, most states have adopted the Uniform Arbitration Act, which is kind of a US version of the UNCITRAL model law. But this statute will most often not apply to international arbitrations. And to the extent that it does, what it provides for is that if a tribunal decides to hold a hearing, and then like in Brazil, it needs to set a time and place and notify the parties of it, right? So this is mostly regarding the right for the parties to be notified and actually know that the hearing will take place. It does not require a hearing to take place in a physical location, right? And some states have also adopted the UNCITRAL model law, and most notably Florida, Texas, and California have adopted versions of the model law. And as we know, the model law does not have an express provision requiring hearings to take place physically, right? What it does have is Article 24, which says that failing parties' agreement, the tribunal has discretion to decide whether to have a hearing or not. And that if a party so requires, the tribunal needs to hold an oral hearing. So then the question becomes, what is an oral hearing? Is it equal to a physical hearing? And then interpretations may, of course, vary. But my interpretation, and I think that's reasonable and justified, is that if you think of what a hearing is, it's a situation that allows parties the possibility of presenting evidence, of cross-examining witnesses, and debating their arguments in the law. And none of that requires them to be physically present in the same place, right? So I'd say that oral hearings under Article 24 of the UNCITRAL model law, as enacted in those states, does not require physical hearing as well. So the conclusion is that there is no express right to physical hearing in US lex arbitrae. And the second question, which is, can that be inferred? I also think the answer is no, right? Because and the reason for that is when you look at case law, first of all, courts are very differential to arbitral tribunals' decisions on procedure, and they are very unlikely to second guess tribunal's decision to have a hearing or the manner in which the hearing will happen. And second of all, when you look at the case law, courts are not concerned with whether the hearing was remote or physical. They're actually concerned with whether the hearing was fundamentally fair. And this concept of fundamental fairness is key and very important, and it will permeate the discussion on all the topics, this one and setting aside and enforcement of foreign arbitral awards. Fundamental fairness is a key concept to understand this issue in the US, right? And what is fundamental fairness? Well, fundamentally fair hearing in the US, as by US courts have found, is one that allows the party full opportunity to present their evidence and arguments, right? So again, nothing suggests that a remote hearing cannot be fundamentally fair, right? Obviously, there may be particular circumstances that need to be assessed case by case, but generally speaking, remote hearings that allow parties an opportunity to present their arguments and present their evidence would fulfill this requirement of fundamental fairness, and therefore there would be no violation of the US lex arbitrae or US arbitration law, generally speaking, by holding a physical hearing, by holding a virtual hearing. And I'd just like to mention very briefly that there is one case, as far as the reporters are aware, there is one case that deals specifically with this issue that came up after the pandemic hit, which is the case from the District Court of Illinois called the Gasp versus FINRA. And what happened there was, this is an arbitration under the FINRA rules, which are the rules that relate to companies that share their that sell their shares in the open market. So that's a parallel. It's very similar to what Brazilian law provides for with CVM, right, where it requires companies trading at a certain level to have arbitration agreements. So that's what FINRA is in the US. So a party tried to file a preliminary injunction trying to bar a remote hearing from taking place, arguing that the FINRA rules provides that parties have the right to attend all hearings, and that the tribunal needs to set a time and place. Again, very similar to what Brazilian law says, and what some state law provisions, the language that they adopt. And there the court refused that injunction, again, just by saying that this is an issue for the tribunal to decide, right? Arbitrators are the ones who should actually decide the procedure, and we will not second guess, we will not look at the decisions that they have made. So the court then dismissed the preliminary injunction. So in summary, I would say there is no right to physical hearing, either expressly or by inference in the US.
Thank you very much, Marcel. And actually, I would just like to stress that your reading of Article 24 of the UNCITRAL model law, that the party's right to an oral hearing does not translate into a right to a physical hearing, is the widest interpretation of this provision that is found in the national reports from the model law jurisdictions, with some exceptions. For instance, the issue is debated in some jurisdictions, but this is the most widely accepted interpretation at this moment, I would say. So thank you very much. And I would now move to our second topic, which regards party autonomy. And in particular, the question whether the arbitrators could order a remote hearing despite the parties' agreement to hold a physical one, and what would be the legal consequences of such an order. So for this question, maybe Marcel, we can start from the United States.
Sure, thank you. And one thing that I think hasn't been mentioned is that Benedetta is currently one of the world's leading authorities on this topic. She has been very active in surveying all the jurisdictions, so she's probably the one who has the most knowledge of all jurisdictions on this aspect. So I would really trust your opinion on these topics and the interpretation of Article 24 of the model law. But okay, so
well, you're absolutely too kind, Marcel.
Okay, so can arbitrators ignore the parties' agreements to have a physical hearing, and what would be the consequences? The short answer for the US, I would say, is no. And the reason for that is that many courts in the US, and that includes the Supreme Court, have consistently held that arbitration agreements are a matter of contract, and they must be enforced in accordance with their terms, right? And that is a very strong position the courts take that leads them to enforce even arbitration agreements that lead to inefficient results, right? So arbitration agreements that would have claims and counterclaims being heard in different forums, like claims in arbitration and counterclaims in courts, that would be enforceable. There is the long-lasting and famous decisions on and discussions on class arbitration agreements, right, in which the Supreme Court has ultimately said, well, regardless of the circumstances of the case, we need to you signed an arbitration agreement, and you need to be bound by it, right? So this is just for instance, the case of Italian Colors, which is a consumer case in which the request for relief was $20,000, but the arbitration costs would amount to $1 million. And the Supreme Court said, well, tough luck, you signed the arbitration agreement, and we need to enforce it according to its terms, right? So what that means for our purposes of today is that if the arbitration agreement makes it clear that the parties intended to have a physical hearing, then the tribunal cannot disregard that intention. And if they do, the arbitral award could be vacated based on one of the grounds in the Federal Arbitration Act, which provides for the setting aside when the tribunal exceeds its authority. But it's very important to note that this intention needs to be absolutely clear. So if the arbitration agreement is silent, or if it is ambiguous, the language of the arbitration agreement itself, or reference by to institutional rules, the tribunal. So if it is silent or have ambiguities, the tribunal does have discretion to decide whether to hold a virtual hearing or not, right? So again, arbitration agreement is a matter of contract, and it needs to be enforced according to its very express terms. So that's the position that the U.S. and the U.S. reporters have taken.
Thank you, Marcel. Thank you very much. And actually, regarding your introduction, I just saw that 2 of the co-editors of the project are following us. So of course, they would be much better positioned than us to comment on these topics. And of course, I welcome them to do so whenever they wish. And regarding the US answer to this question, I found it very interesting because there are actually a number of national reporters who have argued that in their jurisdiction, the arbitrators could overcome the parties' agreement if respecting such agreement would lead to a violation of the arbitral tribunal's duty to conduct the proceedings in an efficient manner and without undue delay, which of course is very different from the US perspective. Now, I would like to hear the Brazilian answer to this question from Rafael. The floor.
Thank you, Benedetta. My short answer to this question under Brazilian law is also, as Marcel mentioned, under US law, is also that in principle, in general terms, the arbitrators cannot ignore the parties' agreement in this regard. But I would include some caveats in that debate here in Brazil, because we do have some controversy in this regard. And to explain the controversy, I would prefer to differentiate 2 scenarios. The first one, which is not usual, is that when you have in the arbitration agreement itself a provision requiring physical hearing. So when the need for a physical hearing is contained within the arbitration agreement. Scenario number 1. In this case, I think there's no controversy. The arbitrator should follow and observe the arbitration agreement, right? Could be arbitration clause, or could be what we call compromisso, or could even be the terms of reference, because under Brazilian law, the terms of reference is part of the arbitration agreement. So we would be more prudent in that regard, because there is a specific ground to set aside an award, a domestic award in Brazil, if you deviate from the arbitration agreement or the terms of reference, right? And that we can discuss in the third topic. So I would say everyone agrees, or most of the authors agrees, that should observe the arbitration agreement. If it said that there should be a physical hearing, you should observe it and not deviate from it. But again, as I mentioned, this is very uncommon and unusual to happen, because usually the parties don't indicate in the arbitration agreement the specific rules for the hearings. Scenario number 2, there's the arbitration agreement is silent, which often occurs. Most likely, this is the most, I would say, this is what happens most when the arbitration agreement is silent on hearings in general, and virtual hearings and physical hearings. But then during the proceedings, of course, the arbitrators may ask the parties whether they would agree to hold the hearing virtually, remotely. The parties can say, no, we want to hold the hearing physically, in person. And both parties can agree to that, right? So that would be a parties agreement during the proceedings. The question is, could the arbitrators then decide otherwise, even though both parties are in agreement that the hearing should be physical? Could the arbitrators say, okay, I understood, but given the other concerns that we have to pay attention to, for instance, the one that you mentioned, Benedetta, the duty to conduct the arbitral proceedings efficiently and without undue delay, for instance, because they could say, look, if we wait to have proper sanitary conditions, we would have to wait, I don't know, 18 months so that we can be physically in the same venue, depending on the location in Brazil. So the question is, can the arbitrators then say, look, understand, but given the other duties that I have to abide to, we will decide to hold the hearing virtually, because doing it physically, it's not feasible at this point, given the sanitary restrictions. This second scenario that I mentioned is the one which gives rise to debate in Brazil. I would say this is the only thing that I mentioned in my report, that it is still unsettled. I think most of the authors and practitioners would say that it is more prudent to respect the parties' agreement within the proceedings, during the proceedings, because by failing to do so, you could open the door to annulment proceedings afterwards. So I think this would be the more conservative approach. But it is unsettled, and I do see the points and the concerns of the arbitrators when they say sometimes they cannot wait for a year until they have the proper conditions to have a physical hearing. So it's still unsettled. I haven't seen, even after I submitted the report, I haven't seen case law in that regard. Still, I think it's too early for that. And what I've seen in some cases, in most cases, that arbitrators have been adopting a prudent approach, trying to accommodate all the concerns, this balance of interest in having an efficient proceedings without undue delay. At the same time, respecting, of course, the sanitary restrictions that we have in place in Brazil, depending on the seat, because different cities have different restrictions and in different periods of time, right? So depending on where you are and when, the restrictions can be different in Brazil. And also the interest of the parties. Sometimes parties want to have a physical hearing because they prefer to conduct the hearing physically. So most arbitrators are, I would say, are being very conscious about it and trying to balance all the interests involved and all the concerns involved. And I haven't seen many problems so far, and haven't heard many problems so far in this regard. So usually arbitrators will follow the parties' agreement. As I mentioned in the beginning, as a general rule, they cannot ignore parties' agreement, especially if it is within the arbitration agreement. And we haven't heard of a case still where, following the parties' agreement would mean to jeopardize the integrity of the proceedings or the integrity or the efficiency of the proceedings, or causing, for instance, the delay of a year or a year and a half. We haven't heard still of a case where this extreme scenario has occurred. So if you have to wait a couple of months to make sure that parties' agreement is respected, why not? So this cautious approach has been taken in Brazil. But the short answer, I would say, is similar to Marcel's answer under US law. In general terms, the arbitrators in Brazil cannot ignore the parties' agreement. And one additional remark that I forgot to mention in my first answer to the first question regarding hearings, just to comment what Marcel mentioned after my presentation. It is possible under Brazilian law to decide the case based solely on documents. Article 22 of the Brazilian Arbitration Act says that the arbitrators may determine the production of X and Y evidence, for instance, the position of parties, examination of witnesses, technical evidence, and other evidence that the arbitrators deem necessary. By using the words may and necessary, evidence that the arbitrators deem necessary, Article 22 is implying that the decision on evidence under Brazilian law is totally within arbitrators' discretion. And usually Brazilian courts support that idea, as Marcel mentioned with respect to US courts, meaning Brazilian courts respect and give arbitrators broad powers under Brazilian Arbitration Act to conduct the proceedings and to decide on evidence, whether evidence is necessary, whether evidence is unnecessary. So they, for instance, they can decide this case will be decided only based on documents, no hearings at all, physical or remote. So that could be a decision under Brazilian law, perfectly valid and fine. And they could also, of course, decide to hold remote hearings if there's no parties agreement to the contrary, as I just mentioned. That's all.
Thank you. Thank you very much for your answers. I see that we have a comment from the audience in the chat, but I would first move to the third and final issue of this panel and then leave it for the Q&A at the end of the discussion. So the third issue is actually, despite we have learned today that neither in Brazil nor in the US there exists a right to a physical hearing, the failure to conduct one could nonetheless constitute a ground for setting aside the arbitral award or for refusing recognition and enforcement of a foreign arbitral award under one of the grounds provided for by the New York Convention. So please, Rafael.
Thank you, Benedetta. In my report, I mentioned that I think it could be the same for Marcel or most of the national reports. We haven't had the time to find case law in that regard because courts haven't decided yet. It's too early. Some countries, you can find precedents, as Marcel mentioned in the US, one precedent, but we still haven't developed the case law on whether we could have set aside proceedings based on virtual hearings in arbitration. So what I did, I explained what I think is the correct answer given Brazilian law framework for arbitration and case law regarding due process, for instance, right? And the conclusion is the following: the problem under Brazilian law will not be, this is my impression, and I think for most scholars and practitioners, the problem will not be the remote hearing itself. The remote hearing per se is not a problem. As I mentioned, this is now common practice in Brazil. Most arbitral chambers are hosting virtual hearings, and even the judiciary, even state courts, judicial courts, they turned into the remote environment with virtual hearings very quickly as well. So our judiciary is also equipped to host virtual hearings and have been doing so since the pandemic hit us in early 2020. So I would say both for judicial proceedings in courts and arbitrations, we have been having virtual hearings without many problems, right? So the problem would not be when we discuss set-aside proceedings or a debate on the enforcement of a foreign arbitral award, a denial to recognize or enforce a foreign arbitral award. In those cases, the problem most likely will not be the mere fact that the hearing was remote. What we have to pay attention, this is the challenge, this is the challenging part, is what happens during such hearing. Because when you are in a physical hearing, it's easier, I would say, to avoid undue practices and some tactics. For instance, communicating with the witness during the testimony. during the examination. When you are in a physical location, everyone in the same room, it's easier to prevent that from occurring, from happening. When you are in a remote setting, you have to be more cautious. And I haven't seen this by, this caution being taken by Brazilian arbitrators. They have been establishing guidelines and rules in advance to make sure that due process concerns will not arise during the hearings. But if you do have a serious due process violations during the remote hearing, not because it is remote, but because something went wrong during the examination of a witness, for instance, if the party is able to prove that such event was detrimental to its due process rights, detrimental to the right to be heard, and there was actual prejudice to the case, meaning you can prove that, because in Brazil, most attempts to attack arbitral awards based on due process violations, due process allegations, most of such attacks, most of the set-aside proceedings dealing with due process violations in Brazil are rejected. So the burden of proof, I would say, by the party attacking the arbitral award in Brazil, the domestic arbitral award, is high. I mean, you have higher standards. The party should prove that not only the actual violation occurred, but the prejudice and the detriment to its right to be heard. So it's very hard to annul an arbitral award in Brazil based on due process violations. But we do have case law indicating that when such violation occurs and is detrimental to the party, we have cases where the award was annulled. So I would say we have to be careful. We have to be more careful in remote hearings. Arbitral institutions and arbitrators in Brazil have been doing it, have been having extra care and attention, and have been extra cautious in remote hearings in Brazil. And I think it is fair to say that we most likely won't have problems for this specific issue of due process concerns during remote hearings in Brazil.
Thank you, Rafael. Now we turn to the United States. Marcel.
Thanks. So I'll try and be straightforward as I can and brief to save some time to Q&A. Should I also deal with enforcement, or are we doing that at a separate moment?
I think we can deal with enforcement if we have some time after we finish with setting aside and leaving some time for the Q&A.
Right, absolutely. Okay, so setting aside, I think to begin with, the first thing it's important to say is that US courts have a pro-arbitration bias that has been developed the last 100 years, almost since the FAA has been enacted. So it sets very high thresholds for arbitral awards to be set aside, right? Here, there are only two possible grounds that the US reporters could think of that could potentially lead to setting aside in this, in regards to physical hearings. The first one is the one I mentioned in the previous topic, which is when there is a specific and express agreement by the parties to have a physical hearing and the tribunal disregards that, then that could lead to setting aside based on the tribunal having exceeded its authority, right? But here, what is important to mention is that some circuits, namely the Second Circuit, which is New York, the Fifth, which is Texas, and the DC Circuit, have found that the mere violation of the Federal Arbitration Act, or these grounds of the Federal Arbitration Act, do not of itself lead to setting aside, and the party has the burden of showing that it was actually prejudiced by the acts that were committed. So again, it's a very high threshold, and even if, at least in these specific circuits, if the tribunal disregarded a provision in the arbitration agreement that is expressly required a physical hearing, then the party will need to show not only that, but that having a remote hearing somehow affected its right to present its case, right? Which is probably going to be very hard for a party to show in this day and age. And the other ground that could potentially lead to setting aside is when the tribunal is guilty of misconduct, which includes refusing to hear material evidence or to postpone the hearing when good cause is shown, right? So here again, the Federal Arbitration Act, and as interpreted by U.S. courts, sets a very high threshold, and courts give great deference to arbitrators, right? So a mere difference of opinion between the judge and the tribunal on how the hearing should have been conducted is certainly not enough for a court to grant setting aside under this provision. So the misconduct that is required for setting aside is when an arbitrator either acts in bad faith or commits an incredibly gross error in conducting the proceedings. And here we're talking about very exceptional cases of ex-party communications, bribery. We are in that scenario, right? So it's very exceptional circumstances that simply holding a physical hearing are hard to reach such threshold. Importantly, U.S. courts have found that an arbitrator's refusal to allow some pieces of evidence to come into the record, that per se is not one of those misconducts that could lead to setting aside. Again, the tribunal has discretion to allow and decide which evidence is material or not. So a tribunal could potentially decide that hearing a certain witness is not necessary or any witness whatsoever, and decide not to hold a hearing and issue an award based on documents, and that would be enforceable and not considered a misconduct. So what a party would need to show under this provision is two things. First, that they had agreed to have a physical hearing. Again, there is no right to physical hearing in the lex arbitrae. And second, that the tribunal's misconduct deprived them of a fundamentally fair proceeding. So we go back to what I said in the beginning. Fundamental fairness is the key to understand how this issue arises in the US, right? And US courts have found that fundamental fairness has three components. First of all is the parties need to have an adequate notice of the arbitration and the arbitration here, if any. Second, they need to have an impartial decision maker. And third, and important to this issue, is the requirement that some courts have labeled as having a hearing on the evidence, right? And when you look at the language, you might be inclined to think that this requires a hearing or even a physical hearing. But when you look at the reasoning behind those decisions and some more recent decisions, you see that the underlying principle is that the parties need to be offered a full and fair opportunity to present evidence, right? So again, that can be done merely by documentary evidence, or that can be done offering evidence in a remote setting. So you can read the fundamental fairness requirement really not as requiring a hearing on the evidence, but requiring a full opportunity for a party to present evidence, right? Which does not need to happen on a physical setting. So in conclusion, US courts are very unlikely to second guess arbitrators' decisions on procedure, and it's very unlikely that holding a remote hearing of a party's objection could lead to setting aside under the Federal Arbitration Act.
Thank you very much. And I'm sorry we did not make it on time to also deal with recognition and enforcement, but maybe we can do so very, very quickly. I see in the chat that we have a comment from Thomas Valenti, commenting that in the USA, FINRA will reopen 62 of its 69 hearing locations in July, while allowing arbitration parties to continue to request remote proceedings. Even if in-person proceedings are allowed, FINRA said arbitration parties can still continue to request a remote hearing, and AAA ICDR offices are open for in-person hearings. So this gives an added argument for those who argue for in-person. So I don't know if Marcel, you want to react to that?
Yeah, no, absolutely. Because right now, or at least last year, we had it was impossible to have a hearing, right? So that was a very strong argument to say, well, either as Rafael said, we can either wait for 2 years or how long, we don't know how long this pandemic is going to last, or we can have a remote hearing. And now that hearing locations are open, that argument is not valid anymore. But I think the arguments that I presented before are still valid, right? So that the lex arbitrii in the US does not provide for a right to a physical hearing, and if the parties have not agreed to one, the tribunal has discretion to decide whether to hold a virtual hearing or a physical hearing, and that would likely not lead to any irregularity that could affect the arbitral award.
Thanks, Marcel. We just received, I don't know if Rafael also wanted to comment on this, sorry.
One comment, because we could have that happening in Brazil, hopefully in the near future, when you have the premises open for a physical hearing. I agree with Marcel, you don't have the argument any longer. If the parties want to have a physical hearing, you don't have the argument any longer as an arbitrator that that won't be possible, right? Because the discussion is the duty of the arbitrator is to conduct the proceedings efficiently and without undue delay. That's the only argument for the arbitrator to still decide to hold remote hearings in spite of ignoring or disregarding the parties' agreement to have a physical hearing. If you have the premises open and available for physical hearing, such argument is no longer valid. So that could change the context. But I think even with the premises open in Brazil, if that happens in the near future, I think we will have in the future hybrid mode, a mixed mode, meaning most of the arbitrations, or at least some of them, will continue to go on remote hearings because we're now used to it. And as long as we can avoid these problems that I mentioned, for instance, communication with witnesses, sometimes it's better, it's faster, it's greener because you don't have to fly everywhere. So I think, at least to some extent, remote hearings are here to stay, even with the premises open and available.
Thank you, Rafael. Of course, that is the question everyone is asking, so that's very interesting. And unless Victoria and João, please stop me if you think we are running out of time, but we do have another question. So very quick reaction from Rafael and Marcel. We have a question from Giovanna Filippi Del Nero, who asks if you think that as the virtual hearings became more common and accepted recently, the arbitration method will become more attractive to potential or current disputants. Do you think parties have been more satisfied with the virtual arbitration hearings since the beginning of the pandemic?
Rafael, do you want to take a first step?
Please, go on.
Right. Yes. So thank you for the question, Giovanna. It's so the best I can do is give you my educated guess, which would be that I think that people, arbitration practitioners and arbitrators and clients are now realizing that having virtual hearings are now an additional tool in arbitration practitioners' toolbox. So it will likely not be suitable for every case, but we now have this brand new world in which you can have an incredibly well-conducted virtual hearing in which you don't need parties to fly to different locations. It's going to be cheaper. It's going to be faster. It's going to be easier to find a schedule that works for everybody. You're going to reduce costs in traveling, in renting places, in renting hotels. So I think that it's not going to be necessarily the new normal for hearings, but I think it's a new category of hearings that we now know that we can have for specific cases that call for it.
Thank you, Marcel. And Rafael, do you think that will give a sort of competitive advantage to arbitration as compared to court litigation, which is also a point that was raised?
It could be an additional advantage depending on, you know, the judicial system that you have as an alternative. When you have more flexibility, as we have in arbitration, it could be an additional advantage. And I echo Marcel's comments on this. I think if you think about it, we were spending a lot of resources in the past to have physical hearings, 100% physical hearings, especially in the context of international arbitration. Imagine for an international arbitrator, a busy one with a tight schedule, with several hearings throughout the year in different locations, in different seats. It was very burdensome to fly the entire world. You think it is, of course, it is. There's a fancy side to it, but if you think, there's also a difficult personal side to it, because that means being away from home and your family most part of the year necessarily. And you know, this new reality allows us to combine personal life, professional life. It allows us to have, as I mentioned before, maybe a hybrid mode, a mixed mode, meaning sometimes it is important to have physical hearings. Sometimes we have to fly. Sometimes we have to be there. But that doesn't mean that we have to do it 100% of the cases. Maybe we can start doing more remote hearings, even after we have the premises available. And we support the Greener Arbitration campaign and initiative. And maybe the pandemic has helped us to have more greener arbitrations, meaning spending less jet fuel. Because if you think about it, one hearing could mean, as Marcel mentioned, 100 people flying the globe. It is a lot. If you just for one arbitration, if you take 1,000 arbitrations ongoing worldwide, it is a lot. So I think we should be more conscious in general with those resources, as well as our clients, you know, the users of arbitrations, companies in general. So you know, there's a good side to what has happened, if any. There's a good side of you know, helping us to have a more balanced life and helping arbitration to become greener and to instead of just, you know, spending and even wasting resources, being more efficient as a dispute resolution method in general.
Thank you both. Thank you very much. So we're ending with this silver lining to COVID-19, I guess. And before leaving the floor again to Victoria and João, let me thank the speakers, Rafael, Alves, and Marcel Cardoso, for the very interesting panel. It was a pleasure to moderate, and of course all the participants for their attention, and especially the ICCA project's co-editors, Giacomo Rojas Elgueta and James Hosking, who have attended the webinar, and of course also Yasmin Lalou. And now I leave the floor again to Victoria and João. Thank you very much.
Thank you, Benedetta, Marcel, and Rafael, for accepting our invitation and for devoting a part of your precious time to this webinar. I'd also like to thank all the attendees. I hope you have enjoyed the event as much as I have. If you have additional questions for our panelists, please feel free to send them to cam@ccbc.org.br. And please stay tuned for more details about the second edition of the Brazilian Arbitration Day at NYU. This is the end of today's event. Take care, and I hope to see you soon.
Thank you very much, everyone.
Thanks,
you.
everyone.